debate on clauses 23A to 53. The question is a Part 2 stand part. The Honourable Leanne Dalzell.
Excellent. I wanted to comment in particular about the amendments as they relate to the Care of Children Act 2004. And I know that this is directly linked to a piece of legislation that we will be dealing with in the House at some stage in the near future. But this whole question around the transfer from the payment for court-appointed counsel to support children and also those that are appointed, the lawyer for the children and also court-appointed counsel to assist in family court proceedings. These issues have been, will be traversed, I think, in a great deal of detail when that particular bill is dealt with. But the legal assistance or the legal aid aspects of it are dealt with it in this bill. And there are a number of issues that I think that we should be concerned about, and I really would like the Minister to take an early call on this particular part in order to work us through the particular issues. Because many of the issues that were raised when we were dealing with this bill were raised again when we were dealing with the family court legislation, and in some respects some of the changes are some of the changes that were made to that piece of legislation directly impact on this and vice versa. And I have to say that, in fact, I think some of the delay and some of the rethinking that was done, which I do give the Minister some credit for. I think that her predecessor probably went a little too far, further than I think a lot of even National Party members felt comfortable with, and we are certainly grateful that this Minister has seen fit to take a step back and have another look. But I think the family court provisions was one of the areas that I think created a significant amount of difficulty, because I know that the family court judges submitted, even though with a different head of bench on both bills, and it was, I think, unusual, certainly in my long experience in this place, to have family court judges come and make submissions, and they were very careful not to cross that line from their knowledge of how the bill would impact on their work as members of the judiciary, to cross that line in terms of policy, which is appropriately that of the government, and they were very clear about that, and I thought that they handled themselves exceptionally well. But what they were concerned about is that some of the changes that the government was making wouldn't necessarily produce the result that the government was trying to achieve, and I thought they were trying to be helpful in that regard. I think that in this area of the family court we have significant problems, and one of the main problems relates to requiring refund of payments in respect of lawyer acting for child, and this is the new sections, clause 27, which introduces new sections 131A to 131C. And what we have in that area is an order requiring refund of payments in respect of lawyer acting for child. And I'll just highlight what the concerns are. So an order referred to in section 131(5), which is dealt with later on, and that's been deleted in my version. I'm just not 100% sure how I've managed to read that. Oh, it's the original legislation. Must order the parties to refund to the Crown the prescribed proportion of the amount paid by the Crown under Section 131 in respect of the appointment of a lawyer appointed under Section 7.1. Each party must pay an equal share of the prescribed proportion. And so we had actually some discussion at the Select Committee about what that prescribed proportion would be. And I think it would be really good for the Minister to place on the record of the House what that prescribed proportion will be, because the way that it's set out in the legislation here is that in the definition part of this, para 6, it says that the proportion is going to be that is prescribed by regulations made under Section 147 for the purpose of this section. And, you know, a regulation-making power with respect to the proportion that's going to be set, you know, really does give, Mr. Chairman, really does give a lot of power to the executive.
Sorry to interrupt the honourable member. The time has come for me to report progress.
Talking about.
The House has resumed. Mr. Chairman.
Mr. Speaker, the committee has completed its consideration of the financial performance in 2011-12 and current operations of Crown entities, public organisations and state enterprises. The committee has further considered the Immigration Amendment Bill and reports it with amendment. The committee has also considered the Legal Assistance Amendment Bill and reports progress. The committee has further considered the Airports Cost Recovery for Processing of International Travellers Bill and reports no progress. The committee has also considered the Plumbers, Gas Fitters and Drain Layers Amendment Bill and reports no progress. Mr. Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Contrary, no. The ayes have it. The Immigration Bill is set down for third reading next sitting day, and the Legal Assistance Amendment Bill, the Airports Cost Recovery for Processing of International Travellers Bill, the Plumbers, Gas Fitters and Drain Layers Amendment Bill are all set down for further consideration in committee next sitting day, and the House will resume at 9 a.m. in the morning. Good evening, everybody.